Hello everyone, and welcome to the SIA Legal webinar series. Today's discussion is an introduction to OHS Law in Australia. We are pleased to welcome our presenter for today, Sam Witten. This webinar is live and interactive. You're encouraged to participate by posting questions to the presenter, which can be typed into the chat box located at the bottom left-hand side of your screen. All questions will be answered throughout and at the end of the presentation. If you are experiencing difficulty hearing the sound during the webinar, please dial the 1-800 support number listed in the chat box. I'd now like to pass you over to Sam to begin.
Good afternoon, everybody, and welcome. There looks to be a pretty big crowd online, so that's very exciting for the first session in this series. I'm really proud to be delivering this and to be continuing the association that our firm, Herbert Smith Freehills, has with the Safety Institute of Australia and in delivering this series of presentations. We're starting with an introduction to the occupational health and safety laws, which is in some respects a pretty big topic to try and cover off on in the time. But that said, I hope to run through some of the key features of the law in Australia and look at sort of where we've come from, where we currently are, and where we might be moving to in terms of some of the things that are on the horizon. If you do have questions as we go through, then please type them into the box. I'm having potentially a slight technical issue at this end in seeing them, but the moderators will otherwise sing them out and I will then be able to hear them and respond to them. So please do pop questions in as we go through or otherwise at the end. So without further ado, we'll get into the formal part of the presentation. And I'm going to show you a slide which is perhaps a little bit scary. It looks like this, which is a mud map of the laws, and it's done from a WA perspective, but there are similar slides that could be provided for each of the states, which is how we see work health and safety laws being applied. So I think one of the things that we often think about in occupational health and safety or work health and safety world, to use the new terminology, is that we're operating under a single piece of legislation. And that's not really the case. It would be lovely if we were, and certainly the Work Health and Safety Act or the Occupational Safety and Health Act in WA or the Occ Health and Safety Act in Victoria is the key piece of legislation that applies to most industry, but there are a number of other pieces of legislation which we should be aware of and which makes the field of occupational health and safety laws relatively complex to navigate. And the first thing to talk about is laws that apply for specific industries. So in almost all of the jurisdictions there are separate laws that govern particular industries, whether that be the mining laws that exist in WA and Queensland and New South Wales, or whether it be specific electricity safety laws that exist in jurisdictions. There's then laws that I suppose we would refer to as activity-based laws, laws that govern activities that organisations are carrying out. And a good example of that might be the national heavy vehicle laws or the other laws that regulate the movement of goods by road. So we've got heavy vehicle laws in all of the jurisdictions and a reform process going on to try and bring those laws together. Rail safety laws would be another example where there is specific legislation governing specific activities in a health and safety context, so the accreditation or the operation of railways with safety management systems, drug and alcohol testing requirements, all of those sorts of things. There's then obviously other specialist areas, offshore petroleum, onshore petroleum, regulation of vessels through the Maritime Act and the Navigation Act. So without getting trapped down too many rabbit holes, I suppose as a starting point, it's important to recognize that when we talk about occupational health and safety laws, we're talking about quite a diverse array of legislation, which makes it a very exciting area to practice in, but also an area which is, relatively complex for practitioners, both in a legal sense and in a practical sense for those of you that work in organisations that are touching on a number of those activities. The good news, though, is that the broad principles that we will talk about this afternoon in terms of risk management and risk-based approach and duty of care type arrangements apply broadly across those pieces of legislation. So whilst when we're undertaking particular activities, we do need to be across the detail, and the devil, as they say, is always in the detail, at a broad brush statement, we can take some comfort from the fact that the general duties that exist under the legislation do apply quite broadly. And so we have talked in Australia for many, many years about the harmonisation of legislation, and I'm sure you're all familiar with that concept. And if those of you who are in WA, you're probably sick to the back teeth of the reform programs that have gone on throughout, since at least 2007, talking about the harmonisation or the modernisation of legislation. And so I think it's important to pause to recognise that we don't, in Australia, have uniform health and safety laws. That was obviously the aim and the intention of looking at the laws that existed and the reform process that happened in 2007, 2008. But what we've ended up with is still state-based legislation. This is not an area like, for example, the employment laws under the Fair Work Act, where the federal government has used its powers and the states have otherwise referred the power to the feds. So we have state-based legislation, and that adds again to the complexity in this area, that whilst we have broadly, at least in the majority of the jurisdictions, adopted laws based on the model, it is not the case that the laws are exactly the same across all of the jurisdictions. So again, I think important to recognise that it is an area where differences do exist between the various jurisdictions. And so where are we at with all of that conversation? Well, the majority of the states have enacted legislation that is based on the model legislation that was put forward and that was drafted back in 2007, 2008. The outliers to that are Victoria, where it has indicated it is comfortable with its existing laws, and Western Australia, where we are still on our journey towards modernising our legislation. And I use the term modernising very carefully there because I don't think we will end up with exactly harmonised legislation. There are inconsistencies, which have grown up in the various pieces of legislation. And that was always going to be one of the problems of having the states enacting their own legislation and therefore being able to change it without the agreement of all of the other jurisdictions. And so we'll come at the back end of this presentation to talk about what Queensland is up to at the moment with its review of its Work Health and Safety Act, but that's an example of where there is debate around changing the laws from the model that was otherwise adopted. And so at a high level, how does the legislation operate? Well, the first thing to recognise is that these are criminal offences that are set up under the legislation. And that is really, really important. I think when we often think about occupational health and safety or work health and safety legislation, we forget that whilst it applies to corporations and to individuals, we do treat it in some respects quite differently to other to other criminal legislation. Part of that comes from the fact that we've got specialist regulators who enforce the legislation as opposed to the police. But partly I think it comes from a a cultural view that we have about the workplace and the regulation of the workplace. And so it is important to recognise that these are criminal offences with large penalties that can be attached, and that should, I guess, drive the behaviours that are expected under the legislation. The next point to note is that the duties that exist under the legislation can apply concurrently. So you can owe duties with another person. Not the case that just because one person owes an obligation under the legislation that means that other parties don't. And the classic example there is in contracting arrangements. A principal engaging a contractor that then might engage subcontractors, all of whom are on site at a particular time or are at various stages of a supply chain, for example. And in those examples, each of the parties in that supply chain or in that contracting arrangement owes concurrent duties. They owe them together at the same time. The next important point to note is that the duties are non-delegable in the sense that you can't contract out of your duties. To be sure, you can manage the risks that you may otherwise hold by appropriately engaging contractors. And there's a large line of case authority that we won't get into today, which talks about how it is appropriate that you can reasonably rely in certain situations on the expertise of a contractor where the activities that that contractor is undertaking are outside of your areas of expertise. But as a starting point, it's very important to recognise that you can't enter into a contract which attempts to contract out of your occupational health and safety duties under the law. And if you do that, the contract that attempts to do that will be void. The little diagram on that slide is really demonstrating some of the key themes about the way in which the legislation is supposed to be enforced and the role that the regulators have. It's important throughout all of this discussion to recognise that the duties in being broad-based duties are duties that are owed by the duty holder, so a person conducting a business or undertaking or an employer to take reasonably practical steps to ensure the health and safety of its workers or its employees. So the laws don't provide a rule book. We can't go to the laws and follow an exact step-by-step guide. We have to be proactive in the way in which we discharge our duties. And I'll come to all of that in a bit more detail in a minute. But that is one of the key features of this legislation. In terms of enforcement then, the regulator can obviously provide assistance. It can provide directions by way of improvement and prohibition notices, and it can take enforcement action where necessary, which we'll come to. And so how does the legislation operate? Well, the legislation, like many other pieces of legislation, operates in a number of ways. An act, which is relatively short, I say relatively because it's still a hefty document, but it sets up the key duties that the duty holders owe, sets up the powers that regulators have, sets up enforcement mechanisms that can be used if somebody has breached the duties or allegedly breached the duties that exist under the Act. There are then the regulations which set out in more detail requirements relating to specific hazards or prescribed obligations. For example, those about consultation with workers, how you go about risk management, what is required to notify incidents, etc., etc. And for those of you that are familiar with the legislation, you'll know that the work health and safety regulations run to close to 700 odd pages. So there is quite a large amount of detail about how specific hazards need to be addressed. We then have a layer below that, and that should really sit underneath a sort of hard line, the codes of practice and guidance and other guidance material. And I say they should sit below a hard line because those documents are not in themselves laws. They can be used as evidence about what a duty holder knew or ought reasonably to have known about a particular risk to health and safety, or about the ways in which health and safety, a risk to health and safety could be managed. But you can't, in and of itself, be prosecuted for non-compliance with a code of practice. You need to be prosecuted for a breach of the Act or a breach of the regulations. Now, the codes of practice and other guidance material are obviously very useful, and we should refer to them. But it's important to recognise that they don't, in and of themselves, have force of law. They are there to provide guidance about how you go about complying with the duties that exist at law. And you should refer to them because they demonstrate industry knowledge about the way in which risks should be managed. So it's important to get some terminology clear, and these are the terminology that is used under the Work Health and Safety Act. So the Act that was developed as a model Act and which has been adopted in the vast majority of the states, as we spoke about. The first thing to understand is this terminology of a person conducting a business or undertaking. And I think there's a degree of confusion about this, even though the law has been in place, the earliest adopter being New South Wales in 2011. There is a degree of confusion about this term. First of all, because it uses the word person. And so naturally people think about natural, physical, flesh and blood people. In fact, the person conducting the business or undertaking was the term that was used to replace the concept of an employer. And the reason that it was chosen as a term was to recognize that working relationships had changed, that more and more people are not engaged as an employee for an employer. There's many contracting arrangements, there's freelancing type arrangements, and this is demonstrated through more and more so in our modern world with the Uberization of the economy. Those people not being employees, those people being contractors to those people being freelance workers, connecting themselves through a platform directly with customers. And so this term of person conducting a business or undertaking was designed to ensure that no matter how workers were engaged by a person conducting a business or undertaking, the person conducting the business or undertaking owed the duty of care, and so that it didn't rely on an employer-employee relationship in order for the duty to be owed. So in most cases, when we think of the person conducting the business or undertaking, we should think of the employer or the business that is undertaking the work. And in most cases, in most commercial arrangements, that's likely to be the PTY Limited type company that is undertaking the work. So I think we need to be clear that the use of the word person is a very lawyer's use of the term to mean both natural people and legal people. The next piece of terminology that it's important to understand is the concept of the worker. And again, this was chosen as a term that was designed to demonstrate the broadness of working relationships, that a worker is any person who conducts work in any capacity and includes employees, contractors, employees of contractors, subcontractors, etc., etc. And so again, it was designed to recognize that not everyone is an employee in a continuing employment relationship, that you could carry out work in many, many ways. In some jurisdictions, volunteers are included in the definition of worker, and that has been quite a fierce debate about whether volunteers should be included in the definition of worker or not. Now, on one view, it doesn't necessarily matter because because volunteers are also owed the duty as other persons, and so the importance of them being workers is really about whether they themselves owe duties as workers, which we'll come to in a moment. So that is one to note that there is differences between the way in which the states have treated their definition of worker and whether volunteers are included or not. A workplace, well, a workplace is any place that work is undertaken. And this is interesting to think about, particularly in working from home type arrangements or in arrangements where people work sort of on the go, whether you're working, checking your emails on your phone and you know, or in an airport lounge or wherever you might be undertaking work. Each of those places is a workplace because the person, a worker, is undertaking work in that place. So then, you know, we owe a duty there, and we then come to what is reasonably practicable for the duty holder to ensure health and safety of their workers whilst they are undertaking work in that place. So an important definition which recognises that the workplace is very broad. It's not just your factory or your office. It's any place a worker is working. There are then the concepts of the management of risk and reasonable practicability, which I'll come to in more detail to talk through. Before that, though, it's also important to recognise the other duty holders under the legislation. So we've talked about the employer, the person conducting the business or undertaking, and that really is the core or key duty holder still. There are others, though, and these include designers, suppliers, installers, manufacturers, all of those people who have a role to play in the supply chain or in the contracting chain. And I'll come in a bit more detail to talk about some upstream duty holders and how those duties apply in practice. It's also important to recognise that this legislation is not all a one-way street. Employees or workers that themselves owe duties under the legislation. And so it is a two-way street between the PCBU or the employer owing duties to its workers, but its workers also owing duties. Officers, so the most senior people within a business, also owe specific duties, and I'll come to those a bit later on. So what are we required to do under the legislation? Well, it's defined ever so slightly differently, but at a very broad brush level, it is more or less the same duty irrespective of which piece of legislation we're dealing with. It is a duty to ensure, so far as reasonably practicable, the health and safety of workers or employees to ensure that they are not exposed to risks to their health and safety. So what does that term reasonable practicability mean? Well, it's a key concept of the legislation, which has been in place for quite some time. And when we talk about the legislation, people often talk about it being general duty based or non-prescriptive. And really what they mean by that is that that duty, the duty to ensure so far as reasonably practicable, to ensure health and safety so far as reasonably practicable, imposes the obligation on the employer to understand its business, understand the risks that arise from that, and to identify the control measures that need to be put in place to manage those risks. Said at the very beginning that the law doesn't give us an exact rule book. It gives us duties which we then need to comply with. And this was one of the features of modern health and safety legislation, which really rose out of the review that was undertaken in the 1970s in the UK. So when you hear people talk about Robins-esque legislation or the Robins principles, that's what they're talking about. Lord Robins was the chair of a committee in the UK that reviewed health and safety legislation. And health and safety legislation, both in the UK and in Australia and in other industrialised economies, had grown out of the very historic Factories Acts that grew up during the Industrial Revolution, where specific people that were particularly vulnerable workers were provided protections, not employing child labour, limiting the work day, and then industry-specific legislation that addressed particular risks, so mining or factories, for example. And so historically, in the 70s, it was realized that there was a complete hodgepodge of legislation, many, many different pieces of legislation that all dealt with very particular risks and which had very prescriptive type requirements. And the concern was that you could meet the letter of the law, but not meet the intent behind the law. So you could effectively comply with the very prescriptive requirements. Guarding must be 35 centimeters across and, at least 2 meters from a machine. Silly examples like that. You could comply with that, but still have workplaces which didn't meet the intention of providing safe workplaces. So one of the very key recommendations which Lord Robens and his committee came up with was to say the legislation, so far as possible, shouldn't be prescriptive. It should set out these broad-based duties which impose the obligation on the employer to understand its workplace and to take the measures that are necessary to ensure health and safety. The regulator couldn't act as a policeman to enforce very prescriptive requirements. That wasn't practical, and that wasn't the way in which modern health and safety legislation should work. And so the very key concept of the legislation is that the duty holder is required to identify hazards, the risks which arise from those hazards, to implement appropriate measures to eliminate or minimize those hazards, and those duties are qualified, particularly in the legislation that we now have, by this test of what is reasonably practicable. We don't have to ensure that no one ever gets injured or killed at work. What we have to do is to ensure that we have taken all reasonably practicable steps to try and eliminate or avoid or minimize that outcome. And so it means that understanding what is reasonably practicable is really important and a fundamental principle of the legislation. And so what we have is a sort of balancing act, if you like, a set of scales, where on the one hand we need to understand the risk itself. What do we know or ought reasonably to know about a risk? What is the likelihood of that arising? What are the consequences of it if it does arise? So how serious is an injury, for example, likely to be? And then what do we know about the ways in which we have of mitigating that risk? Once we've looked at all of those things, we're allowed to look at what the cost of implementing a particular measure to ensure health and safety is. But cost must be looked at last, and it's not the the first thing that we go to, or necessarily the deciding factor. And so that should be familiar to all of you, because it is a risk assessment-based process, and I'm sure that you're all familiar with our nice 3x3 or 5x5 matrices that look at likelihood and consequence. The law requires a very similar assessment. What do we know about a risk? What do we know about the ways in which we can mitigate that risk? And then what's the cost of implementing the measure to control that risk? And there's a long line of case authority that discusses what that means. To give a very silly example, we all know that in office-based environments, or indeed most work-based environments, we all deal with a lot of paper. And paper cuts are an unfortunate consequence of dealing with paper. I'm sure we've all had one. But the consequence of sustaining a paper cut is very, very low. We know, and particularly as technology is changing and improving, that there are ways of having entirely paperless offices. We can eliminate paper, and if we eliminated paper, we would eliminate the risk of people getting paper cuts. However, the cost of implementing that type of a measure, when it is balanced against what the consequence of the risk that you are trying to control is grossly disproportionate. And that's the key test here. If the cost of implementing a measure is grossly disproportionate to the risk that you are trying to control, you can argue that it is not reasonably practicable to implement the measure. So in our paper cut example, we would argue that it is not reasonably practicable to implement paperless offices. We don't have to do it in order to comply with the law. But if we take a more realistic example, people working at heights, we know that the likelihood of people working at heights becoming injured if appropriate controls aren't in place is high. We know that the consequences of that risk are high. People can be very seriously injured or worse. And so we need to identify what the available means of mitigating that risk are. And there's a whole host of things we can do, full protection, full restraints, that work through the sort of hierarchy, and obviously the best being don't have people working at heights, but if that's not practicable, then we need to have another measure in place. And then we look at, well, what's the cost of implementing those measures? Some of those will be relatively uncostly, some of them will be very costly, but we need to go through an assessment exercise of, is the cost of implementing the measure grossly disproportionate to the risk that we are trying to control? Which means that understanding risk management is important, the fundamental concept of the legislation, and I'm sure that this hierarchy of controls is familiar to all of you. And we sometimes see that triangle the other way around, but as a starting point, if we can eliminate a risk, so eliminate people from being harmed, we should do that. If we can't do that, we should substitute the thing that causes the risk with something else. Is there a less hazardous substance, for example, that we could use? Is there a less risky process that we could adopt? If we can't eliminate or substitute the risk, then we should isolate people from the risk. If we can't do that, then can we implement engineering controls, administrative controls follow that, and then lastly, personal protective equipment. Now, I think it's probably fair to say that the focus in a number of workplaces tends to be on personal protective equipment and administrative controls. And I'd be interested for your thoughts on how you think your workplaces go with this. But my experience is that we like, and lawyers are guilty of this as much as anybody else, we like paper. We like having administrative controls about policies and procedures. To be sure, they have a place to play, and they're easy to implement, but they don't necessarily have, they're not necessarily as effective as higher order controls such as engineering or isolating people. So the duties that we owe then as an employer or a person conducting a business or undertaking extend to ensuring, so far as reasonably practical, the health and safety of our employees, contractors, and other people at the workplace. And the broad duty under the legislation that says we must ensure, so far as reasonably practical, health and safety, then requires us to do particular things. Generally requires us to ensure that the workplace itself is safe. Is the environment itself safe? Are there safe procedures in place? Is the equipment that we're providing people to use appropriate? Are we using plant and substances that is appropriate? Have we given training, instruction, and information to our workers that is appropriate for them to meet their requirements? And so, without limiting the broadness of the general duty, there are specific examples about what we must do in order to demonstrate that we have reached in order to discharge that duty, and those are those things. Additionally, there are some other things that we might need to do to achieve compliance, monitoring employee health, for example, particularly if we've got workers that are undertaking particular processes, working with lead, for example. Are we providing information in all languages that people can understand the information, instruction, and training that we're giving them? Are we monitoring workplace conditions? So, for example, respiratory dust or the heat and coldness of a workplace. Do we have issue resolution procedures? So if a safety concern or complaint gets raised, can we deal with that? and consultation with employees and contractors on work health and safety matters. Consultation is a really, really important piece in the legislation, and it's one of those principles that Lord Robins and his buddies came up with to say that health and safety legislation should involve employees, it should involve the workers. And the reason for that being that if we've got people on the shop floor, as it were, those people are probably best placed to understand what the risks involved in a particular process are. So if we want to understand that, what should we do? We should go talk to them and understand what they understand about the risks and what ideas they have about the ways to mitigate those risks. So that theme continues to run through all modern work health and safety legislation. Involvement of the workers is very, very key in the legislation, and now more broadly under the work health and safety legislation, consultation with other duty holders has become recognised as important. In the jurisdictions that don't have that haven't yet adopted the work health and safety legislation, there is the concept of deemed employees, so that even though you're not an employee, you can still be owed the general duty of care. So in WA, employee is defined to include independent contractors and their employees to the extent that the principal has control over those persons or over the activities that they're undertaking, or they would have had control over them but for an agreement that they've entered into which attempts to limit that degree of control. Similarly, in Victoria, employees is defined to include contractors, etc. So even though people are not employees, they are, irrespective of which jurisdiction we're in, owed the primary duty of care. One of the other duties that it's important to note is the occupier or controller of a workplace, and they are under a duty to ensure that the workplace itself is safe, that there is safe access and egress, access to and egress from the workplace. So an important one to bear in mind in landlord and tenancy type arrangements, who is the occupier of the workplace, who is the controller of the workplace. Similarly, in arrangements where, in principal contractor relationships where you've got somebody who may be control of a workplace. So important to recognise that there's a specific obligation there. I touched on the fact that there are a number of other obligations under the legislation on upstream duty holders. And these are the duties that are imposed on manufacturers, suppliers, importers, etc. under the legislation. And so it's important to recognise that each of those people in the supply chain has duties, duties to ensure that the things that they are manufacturing, supplying, importing, as the case may be, are, so far as reasonably practicable, safe. And in the case of plant and structures, to arrange for appropriate testing and examination and to pass on the results of that testing and examination up the chain. There are also specific obligations on designers and installers of plant and equipment. And we've seen in recent times a particular focus on upstream duty holders in the way in which the legislation has been enforced. This example is actually from the old, now repealed Commonwealth legislation, but it was a prosecution of the designer and manufacturer of some immigration support vessels. The Department of Border Protection had entered into a contract for the delivery of these vessels and had specified that they were to meet relevant Australian standards and other marine standards, as you would expect. The vessels, in fact, didn't, and tragically, one of the vessels was involved in an incident where it overturned with people on board, including asylum seekers, and all were lost at sea. The designer / manufacturer of those vessels was prosecuted for breaching their duties in relation to the safe design and manufacture of the vessel. So it's an example of where the laws are reaching into parties that are up the supply chain that are not the direct employer of the people that might be the end users of, in this case, vessels, but otherwise the end users of plant and equipment. Changing gear a little bit then, I wanted to talk quickly about the employee or the worker duty. Unlike the duty of reasonable practicability that is owed by the employer or the person conducting the business or undertaking, this is a duty of reasonable care. So it's a lower duty, doesn't require us to go through that as weighing up assessment exercise of what do we know about risk, what are the likelihood consequences, etc. What it requires is that the person acts in a way which we would expect them to act when compared to their peers. So that allows us to look at things like their skills, their qualification, their experience, and say, well, a very experienced person would be expected to behave in a way which is better or a higher duty than a very inexperienced person, because that is taken up in or included in the test of what reasonable care is. But it's a test of, has this person acted reasonably when compared to their peers, or have they acted completely inappropriately, and if they have, then they should be liable to prosecution. The duty which applies is a duty to take care for their own health and safety and the health and safety of others. So duty to the self and duty to ensure that their acts or their omissions don't expose other people to a risk to their health and safety. There is then a focus on individual accountability. And as I said at the beginning, it's not all a one-way street, which I think from an employer's perspective gives some comfort and means that employees have a duty of their own, take reasonable care, comply with instructions, policies, procedures, the employer, etc. Under the work health and safety legislation, and this was new under the work health and safety legislation, other people at the workplace also owe a duty. So visitors, for example, have a specific obligation under the work health and safety legislation to take reasonable care for their own health and safety and not to expose others to a risk to their health and safety. And so we've talked about this. Employees can be found not to have exercised reasonable care where their conduct falls so far below what a reasonable person would do in the circumstances that warrants criminal punishment. So those are the sort of fundamental underpinnings, principles of the legislation. What I want to do now is to take a moment to talk in more detail about risk management. And then we'll come to some of the other concepts in terms of officer duties and penalties and enforcement that exist under the legislation. The practical process of risk management, which is what is required to meet our general duties, remembering that the obligation is on the duty holder, the employer or the person conducting the business or undertaking, to understand its business, identify the hazards, identify the risks that are associated with each of those hazards, and then assess those risks. So in a very practical way, the process that must be followed by the duty holder is to have a very detailed knowledge of their business and the things that can give rise to risk in the way in which they operate their business. That little diagram there demonstrates that this is an ongoing process, continual ongoing requirement. It's not just a point-in-time assessment. And that's important because as technology changes, as new things come onto the market, we're constantly required to reassess is what we're doing the best way that we can ensure health and safety? So, an example which is maybe which kind of ebbs and flows in its importance or in the attention that it receives in the popular media is whether there is any evidence at all that the use of mobile phones contributes to brain tumours or cancers. And so there has been some research that suggests that they might, other research which suggests that it doesn't. But it's an issue which people should remain alive to, that if the research was to suddenly sway very much in one direction to say that, yes, there is substantial evidence that prolonged use of mobile phones causes cancers, and we've got a cohort of employees or workers who are, I don't know, salespeople on the road a lot, or people that are out in the field and constantly using mobile phones, we may say, well, hang on, what do we need to do to take reasonably practicable steps to ensure their health and safety? That's one example of where new information is coming available, where we are required to continually review the risks and to then review the control measures that might be available to mitigate those risks. I talked about consultation before, and it is fundamental to the process of risk management. Each of the jurisdictions provides for consultations, and the objective is to ensure that informed decisions are made about the ways in which risks can be eliminated or mitigated. And so it is fundamental that consultation mechanisms are established, whether that be through health and safety representatives or committees or other structures, so that the duty holder of the person conducting the business or undertaking or the employer has an understanding and has input from its employees and workers into the risk management process. In Victoria, specific requirements there, you need to consult with workers when identifying or assessing hazards or risks, when making decisions about the adequacy of welfare facilities and decisions about resolving health and safety issues or proposed changes to the workplace. So some specific requirements. So the next little section that I want to touch on is director and senior managers' liability under the legislation. And the officer liability is one of those areas which is different across the jurisdictions, at least different in the General Industry Occupational Safety and Health Act, Occupational Health and Safety Act, Work Health and Safety Act. It was one of the key principles to come out in the work health and safety legislation to introduce this concept of due diligence. Due diligence requirements were new in the legislation. It wasn't that officers previously didn't owe duties, but what it introduced is a proactive requirement for officers of an organisation, so the most senior people within the organisation, to proactively demonstrate that they are ensuring that the business of which they are an officer can meet its obligations under the legislation. And that's important. The drafters of the legislation, the three-member panel, took a lot of time discussing this in their two reports, and formed the view that if you want to drive change in health and safety, that should be driven from the top. And one of the ways of doing that is to impose a specific obligation and with specific penalties for non-compliance to those people that are the most senior people within the organisation. By way of contrast, in WA, an offence, a senior member of management can be guilty of an offence if you can demonstrate that, one, the business has committed an offence, and two, that the offence occurred with the consent or connivance of, or was attributable to the willful neglect of the officer. A much higher bar to reach in WA a two-step test to say, has the business committed an offence? Was that offence attributable to the officer's consent, connivance or willful neglect in order to find a senior member of management guilty of an offence? Very different to the due diligence proactive obligation that otherwise exists. In Victoria, the test is whether the officer failed to exercise reasonable care, but again it requires that the organisation has itself committed an offence. So under the work health and safety legislation, an officer has the definition that it is given under the Corporations Act, which means statutory directors, so those people who are nominated on the ASIC forms as being directors of a business, or the company secretary of a business, and it also includes people who make or participate in making decisions that affect the whole or a substantial part of the business. So those people that participate in decisions about the strategy, direction of the whole business or a very substantial part of the business are all officers of the business. And the due diligence requirements require taking reasonable steps to ensure that the business can meet its corporate duties. And that includes, in a non-exhaustive list, having up-to-date knowledge of work health and safety matters, understanding the operations and the hazards and the risks that arise from those operations, ensuring that there are appropriate resources allocated to eliminate or minimise work health and safety risks. So that would be both financial and non-financial resources, having processes to receive information about work health and safety risks, and having a management system in place. And then lastly, verifying that all of those things are in place. So the last little section, which I might just whiz through to leave some time for questions, roles and powers of inspectors. Well, at a high level, the inspectorate and the regulators of work health and safety legislation have very broad powers. In some respects, their powers are greater than the powers of the police. They have the right, most jurisdictions, to ask questions, and for the right to silence to be abrogated. So unlike in a police interview where you can say no comment, no comment, no comment, in a work health and safety situation, in most jurisdictions, that right is abrogated, and instead, if you do give information, that information, if it's given in a compelled way, cannot be used against the individual in a prosecution of that individual. The public policy reason behind that being that where a work health and safety incident has occurred, we should be able to get to the bottom of what has gone on and should understand what has happened and what measures might need to be put in place and communicated across industry more broadly to ensure that a similar incident doesn't happen in the future. So there's very good basis for the inspectors having such broad powers, but it does create a situation where they do have the right to, enter premises, require documents, speak with witnesses, all of which are very broad powers. They have the rights to issue improvement and prohibition notices, so there is a range of enforcement mechanisms available, and I've talked about the abrogation of right to silence in most of the jurisdictions. Prosecutions, prosecutions can be instituted for offences under the Acts and the regulations, and there are a number of considerations around when it is appropriate to consider imposing a penalty or bringing a prosecution. And all of the jurisdictions have prosecution and enforcement policies that talk about these factors, whether there is with the seriousness, what the mitigating or aggregating factors were, what the level of public concern about a matter is, and these factors play into whether the prosecution should be brought in the first place, and if it is brought, the level of penalty that should be imposed. Under the Work Health and Safety Act, The penalties are, as headline figures, quite high. They're graduated depending on the level of severity of the offence, and you'll see that that penalty can be imposed on the person conducting the business or undertaking, corporations, officers and workers for each of the category of offending. In the non-harmonised jurisdictions, similar penalties similar penalties in Victoria, lower penalties in WA, although moves to change that. There are a range of other sentencing options which are used to a greater or lesser extent. Enforceable undertakings is one that doesn't appear on that little wheel, but is one which we have seen used in lieu of prosecution in some of the jurisdictions. So particularly in New South Wales, a number of organisations have entered into an agreement with the regulator that they won't be prosecuted, but they will contribute an amount of money towards health and safety improvements or community projects, etc., etc. We started the presentation by talking about the degree of complexity in the health and safety legislation, and I might conclude it by mentioning that, of course, health and safety laws interact with other legal issues, particularly industrial relations issues, workers' compensation issues, and matters of discrimination, bullying, return to work, and rostering and hours of work. So, for those of us that are health and safety professionals, we should think about the way in which our work interlinks with those of our colleagues in our industrial relations or employment relations team, and shouldn't view our area too much in isolation. Very lastly, I want to touch very quickly on what's on the horizon. There is, as I've mentioned a couple of times, proposed reform in WA. We the government has recently convened a ministerial advisory panel to advise on what the shape and nature of the legislation in WA should look like. So that is a process that is ongoing. There are revisions to the heavy vehicle national laws to make those duties less prescriptive and more general duty based. And there is the ongoing inquiry into Queensland's work health and safety laws, which may result in a range of findings, including whether those laws include corporate manslaughter provisions, etc. So there's a degree of change. This is an exciting space where things continue to be reviewed and changed, and the laws certainly are by no means static. I'm conscious that I've talked for a very long time, and I did warn you at the beginning that this was an area which was hard to deal with in the time because it's such a broad topic. But hopefully you can all stick around for questions if there are any questions. I didn't see any come through, Jeff, as we were going along. I don't know whether that's my system or whether any didn't come through. But if there are any questions now, then please feel free to raise them. I think Jeff will shout them out so that I can hear them, and then I can answer them on the audio.
Hi Sam, so we do have some questions. The first question is from Barbara. With all the various bits of industry and activity-based legislation, does OHS or WHS trump all others if something has gone wrong?
The short answer to that, Barbara, is no. Look, the application of the various bits of legislation turns on the particular piece of legislation that you're talking about. But let's take the example of mine safety specific legislation, for example. Typically, the mine safety legislation will apply to the mine site to the exclusion of the Work Health and Safety or Occupational Health and Safety Act. If we take rail safety, for example, then the rail safety national laws typically operate in conjunction with the health and safety laws, but for there being any inconsistencies between the laws, but they will deal with sort of separate areas. So the rail safety law will deal with the accreditation of the rail operator and specific rail safety offences, and the work health and safety laws will obviously continue to deal with the work health and safety type duties, but there isn't one which trumps all others. It will then turn on, what the facts of the incident were and where, what breach it is alleged that has occurred. So there isn't a grand trump card in all of this, unfortunately.
Next question is from Tony. If 8 of the 9 jurisdictions are either at harmonised terminus or, as in the case of WA, moving towards that outcome, what really is stopping Victoria from moving that way?
That's a good question, Tony. Look, I think it has been it's been an interesting journey because a lot of the Victorian laws were picked up by the drafters of the model legislation, and so on one view, it would have been Victoria would have had the least amount of change in adopting the model legislation. A few years ago, there was under a government of a different political colour to the current Victorian government, there was a report that was commissioned which looked at what the cost of implementing harmonised laws would be. And it was based on a series of interviews that were conducted with businesses, and that report came up with a figure. I can't remember the exact figure now, but it was a pretty big number into the multiple hundreds of millions of dollars for the cost of the Victorian government, cost of the Victorian economy, sorry, of introducing harmonised laws. What that report sort of failed to indicate, though, was that in a number of businesses that it had spoken to, what was clear was that it was talking about cost of compliance generally, and that those businesses may have needed to up their game somewhat to comply with all of the existing requirements under the Victorian legislation in any event. So, but once that report was out there, it became a bit of a political hot potato as to, well, why should we adopt some laws that are going to be an additional cost impost on doing business in Victoria if there is little to be gained. So, it's a political call as opposed to anything else, and that really, I guess, remains the sticking point. As well as an argument from Victoria that, well, our existing laws work perfectly well. They allow us to enforce. We've got a good safety record, so they argue in Victoria. And so why do we need to change?
Next question is from David. Is the title of responsible person now no longer applicable?
I'm not entirely sure what you're referring to there directly, Dave. I think it's a South Australian question, I think is where you're coming from with it. And that's right, that under the old South Australian legislation, there was a responsible person definition. That doesn't exist now under the SIA Act, which is fairly closely aligned with the model. That the key duty holders are the person conducting the business or undertaking, and then the duties that flow from that, as well as the other duties that we've talked about, being imposed on manufacturers, suppliers, etc. And so you've got the officer-based duties on the senior members of the management, directors and others, so that you don't have the responsible person type test. You've got the officers of the business needing to exercise due diligence to demonstrate that they have complied with their duties.
Next question is from Tony. Say a person who spoke or wrote English as their second language. If an employee was engaged or employed where at each stage of their employment process English was the sole language used, and there was a requirement that understanding written and spoken English is a prerequisite of gaining employment, Is there any further need to present OHS information to that person in their native language?
I think the short answer to that question would be no, that if they have appropriately demonstrated that they can communicate in English, you would have a reasonable basis for arguing that it wasn't necessary to provide the information in their native language. Now, of course, it's really going to turn on how robustly you can demonstrate that they have communicated in English. But I guess as a matter of practice, if they've been in the business for some time, the work environment has all been in English, and they have been communicating and understanding instructions, etc., etc. Then I can't see on what basis you would argue that they didn't then understand what was going on, and as to why they would then need the information provided to them in their mother tongue.
Does the upstream duty holder also have an obligation to hand their assessment information down the food chain as well?
I think the question there is there an information flow up and down the chain? There are specific requirements in the legislation about how information is passed on, where specific tests have been done for, like the design and manufacture of plant, and there are specific obligations where a structure has been built to then the information be passed on to the end user. So it would really depend on the circumstances that we're talking about as to where the information needs to flow and whether there is a specific requirement in the legislation given the roles that the party is holding. I know that's a bit of a wishy-washy answer. Maybe if you've got sort of the specific example you were thinking of, I might be able to address that more clearly.
Question from Barbara. Assume Tasmania fits under South Australia, Northern Territory, New South Wales, Queensland sector group are different for not-for-profit groups. Who is an officer?
So I haven't spent much time talking about Tas. Sorry, the laws in Tas are the model laws in a pretty close adoption of the models. I can't remember off the top of my head the way in which Tasmania has dealt with volunteers under its definition of worker. Just going to pull it up. Bear with me. I might have to take that question on notice just to check. And if you wanted to, you could drop me an email, Barbara, and I can confirm the treatment of the definition of workers under the Tas Act, if that's okay.
Next question. How do WHS duty holder also have an obligation to hand their assessment?
How do they have a duty to hand their assessment? I'm not sure what the question is there. This is one of the wonderful joys of doing webinars, isn't it? It's all a little bit stilted. If we're talking about risk assessments there, then there are specific requirements when we're talking about construction work for safe work method statements to be passed on, particularly where you're talking about a construction project. So depending on which jurisdiction you're in, but generally construction work which has a value over $250,000, then there are specific requirements about contractors providing safe work method statements to the principal, and so in that case there are specific requirements about handing on risk assessments. Otherwise, yeah, I'm just not sure what the specific question is there.
Next question. How do you see Victorian legislation against harmonised legislation? Is it relatively stronger or somehow weaker?
Look, I guess that's a very good question. I don't know that there is. I don't know that you would necessarily argue that it is weaker. It's different. I guess the key differences really are the way in which the duty holders are set up. So, you know, the terminology of person conducting a business or undertaking owing duties to workers, I think, is a you know, a feature of the Model Act which makes it very, very clear that duties are owed irrespective of what the arrangement is. And to be sure, Victoria, you know, gets there with the way in which it does it, but it's just not, you know, as clear. I guess the other key difference is the way in which officers are treated, and so the due diligence requirements don't exist. You know, but I don't know that you would necessarily argue that it is weaker. It's just different, I guess, is the short answer.
How are volunteer rights protected by laws from OHS, WHS perspective?
So the volunteers, I guess, are protected in two ways. In the jurisdictions in which the definition of worker includes a volunteer, which I've just checked, Barbara, and the Tasmanian legislation does include volunteers as workers. So in those jurisdictions, they are clearly owed the general duty of care that the PCBU must ensure, so far as reasonably practicable, the health and safety of workers, which then includes volunteers. In jurisdictions where volunteers are not specifically included as workers, then they are other persons that are at the workplace and are therefore owed that duty. So the duty of the under the Work Health and Safety Act terminology, the PCBU owing the duty to take reasonable care to ensure that other persons that are at the workplace are not exposed to a risk to their health and safety as a result of the work that the PCBU is undertaking. In a WA context, the duty that a employer has to ensure that persons are not exposed to hazards from the work that is undertaken by the employer or from the work methodology of the employer. So volunteers are owed duties, you know, either as workers where they are specifically included in workers, or they're owed duties as other persons that are at the workplace or that might be exposed to risk from the work of the duty holder.
For the sake of proactive compliance and assistance, does the government provide any awareness or guidance other than guidelines?
Yes, is the short answer. I mean, I guess the regulators around the country, both for general work health and safety and for industry-specific legislation, do publish a whole bunch of bits of material. You know, whether that be codes of practice, which are specifically, you know, agreed and endorsed and put out under the legislation, or whether it be other bits of guidance material, you know, safety alerts, you know, information sheets, all of those sorts of things. So there is a wealth of guidance material out there. I guess one of the issues that many people face is actually keeping on top of all of that stuff and ensuring that you remain familiar with it, because one of the risks is that stuff is put out and then you're sort of deemed to be aware of it. It falls within the what do we know or ought we reasonably to know about something. Well, I guess we ought reasonably to know about what the regulator has put out. So, those sort of safety alert, safety bulletin type bits of information are in their own right bits of information guidance that we should be aware of.
Thanks, Sam. Just in the interest of time, apologies, but we're just going to have to wrap up the Q&A session. So any questions that have been unanswered will be responded to via email after the webinar. So Sam, I'll just hand back to you for any closing remarks.
Lovely. Thank you all very much for attending. Sorry that we have had to wrap it up, but if you did have other questions, then feel free to shoot them through. And I will endeavour to come back to you. But otherwise, thanks very much for your attendance. It's been really enjoyable delivering it, and hope to see you all at some of the other future sessions.
Thank you, Sam, for your presentation, and thank you to everyone for attending today's webinar. Have a great afternoon.